Okay, so let's talk about Section 2. You've got a couple of articles, you've got a couple of cases. And I know the remedies and domain name lawsuits link is broken. That's mostly done by way of agreement with the registration process by arbitration these days, with respect to whatever the domain name would be, whoever you've registered with. Those remedies are likely resolved by way of contract, at least initially, with respect to the registration process. Well, let's talk a little bit about first the Americans with Disability Act, and it starts, at least part of it, the analysis starts with Casey Martin's case from more than a few years back now, where he was a disabled golfer who wanted the benefit of being able to use a cart in order to compete on the professional golf tour. And the PGA said that they thought that would fundamentally alter the competition, and in order for the Americans with Disability Act to apply at all, the person has to be otherwise qualified to be able to do the work, and then with respect to them being able to perform the work, the court has to decide what, or the person should decide what a reasonable accommodation would be. Just for a little background, there was a significant amendment to the Americans with Disability Act, which was initially passed in 1990 under the first President Bush, and who at the time talked about this being the Civil Rights for the Disabled Act. And then in 2008, there was some clarification to the Act, which as a general matter requires employers or places of public accommodation to make reasonable accommodation for people with disabilities who would otherwise be able to perform the task if that accommodation, that reasonable accommodation, is granted. And in order to qualify under the Act, there has to be both a disability, and then that disability must substantially limit one or more major life activities. Or you have to have a record of such an impairment or being regarded as having an impairment. So the question is, to what extent does that impairment affect a major life activity? And it has to substantially limit that activity. And there's a non-exhaustive list of those activities: reading, bending, communicating, writing, walking, sleeping, working. There's a whole bunch of different things that when we're talking about it, as to what would classify for coverage under the Americans with Disability Act, which is a federal act. So, not to go overly deep into the history of it, it's supposed to level the playing field. That was the argument upon its initial passage. Does Casey Martin's request for a cart, does that, well, first of all, is he disabled sufficiently within the Act?
Yes.
Why? He can't walk. Well, he can, but he can walk with difficulty. So that's a disability which limits a major life activity.
Yes. Yeah. Yes.
So we can get past some of the question, the argument about he just wants an advantage, or because he does have a disability, but he still wants an advantage. Charlie?
He doesn't want the advantage.
They even say every time he walks there's a high degree of fracture and amputation. So it's not just a simple, slight pain or tingle in your leg when you're walking. It's like a very serious injury.
So we're satisfied that he's got a disability, and it does affect a major life activity.
Yes.
And so now we'll go to the next part about reasonable accommodations, because if he's got a disability which affects a major life activity, then there has to be a reasonable accommodation, either if it's a place of public accommodation or if it's an employer of so many employees. With respect to places of public accommodation, that would mean that if you don't have a wheelchair ramp, you would have to put a wheelchair ramp in?
Unless it's an extreme hardship.
Well, what's that mean, unless it's an extreme hardship?
You're a small business, it's going to put you out of business to do it. They're not going to make you do it because of, obviously, counterintuitive.
Well, how small a business would it have to be for you not to be allow or provide for everyone to have a right of access?
Did they
I
say?
mean, because everyone's going to say it's a hardship, right? I'm not putting an elevator in. It's a hardship.
But it depends on
Huh?
Have to close you down. You couldn't just show, oh, we're not going to make, $3 million this year. I mean, it would have to be something that really you can't afford it. You have to show, that you can't afford it.
What?
I think in terms of small business, they said like 5 was the number or something like that.
So it's a relatively small business. So, well, tell me about Casey Martin then. Would you give him the accommodation? So everyone else has to walk, but he gets to ride.
Absolutely.
Absolutely. Not a competitive.
I don't know.
Yeah, no,
Mark's case,
Jump in.
it was the golf cart in between holes. So as far as his performance in the actual game, it's really irrelevant, especially since he has this disability, a progressive disability.
I bought the disability argument when Arnold Palmer and Nicholas testified, and they said that when you're walking that last grade, it matters. It's the difference between winning and losing. I think the fact that he wasn't walking was a bit of an advantage.
He did, at some level, he's got an advantage not having to walk the course. Go ahead.
But I agree with the court, pointed out that because of his disease, he's in so much pain, that that's his disadvantage. Like, it balances out the fact that he's fatigue because of his disease.
If there's any advantage, it's offset by the loss from his disability. Charlie?
Well, as far as Arnold Palmer and Jack Nicklaus, the fact that they said that, I take some credibility away from them. I think less of them after seeing what they said.
Why?
But because yes, they talk about that fatigue that kicks in as you're walking on that 18th hole, blah blah blah. There's medical testimony that this guy still walks 25% of what everyone else walks, and to say that he's less fatigued than the people that walked the whole 18 holes, you're kidding yourself. This guy's severely handicapped. The fatigue that he has to go through with still walking over a mile throughout the 18.
If he's severely fatigued, then maybe he's not otherwise qualified to begin with, no?
Well,
No, he's qualified.
Well, what makes him qualified if he can't walk the course?
He's got a particular skill set, and the case even says that walking isn't necessary
Exactly.
for the game. It's just something that's been done since the inception of the game. You don't need
Well, it's part and parcel of the course is to walk the course. I think that maybe perhaps they would have been better served to say that he doesn't meet the physical qualifications to play the game. Because if he can't walk, how's he supposed to pick up a 9-iron and tee off?
Well, obviously,
He does, but they're using the probabilities of him breaking a bone walking, but they don't mention it when he tees off. You know what I mean? He does tee off, but he can't walk. I think it's a double standard. I think they're really using a crutch here.
Go ahead.
I was going to say, but obviously, I mean, he obviously is qualified. If they went through the process to qualify for the PGA Tour is really difficult, and he got there. So he's obviously a qualified golfer.
But he's never faced that mental fatigue on the 4th day on the 18th green.
But his mental fatigue is, I might break a bone and have my leg amputated if I were exhaust myself. Yeah.
Go ahead.
I could, well, two things. One, I could see if he is literally just, he takes the cart to where the ball is, and he literally just steps off the cart, hits, steps back on. But they say that he's still walking 25% of what the regular golfer would walk.
Yeah, but that's from going down the fairway to his ball back to he's not walking from his tee shot to the ball.
No,
by any means.
You know,
He's just staying on the cart path because these are premier courses. He's not driving to his ball like us Sunday golfers drinking beer.
Yeah, but they mention his personal circumstance, and they say, I mean, they say it gets into like a long factual thing. One of the quotes about like, oh, a long-standing thing about fatigue and walking, and I think it basically says like, no, like golf is hitting a ball with a stick, and that's kind of what golf is. That's what
Except
comes
for the
from like
Hall of
Scotland
Famers.
and all. They go back into it. That walking really isn't part of golf.
Walking's not a fundamental part of the game.
Right. And that was so their argument was.
It may not be part of the game, but the PGA said that on this particular last hole, that's part.
Not just the last hole, and for the 18 holes, they are expected to walk.
So that's part of the game.
For 4 days.
It's part of the competition, almost. I mean, I'll change it from the game to the competition. Because Charlie says, well, he's walking 25% of what the others do. Well, that means he's not walking 75% of what the others are required to do and still compete against them.
But sure, every golfer out there has a caddy that carries their stuff around anyway. It's not like, a normal golfer walks a couple of miles and around. It's not that tolling, really, when you have someone else carrying your stuff all around for you. I don't think he's getting an advantage at all.
I've always thought about this when I read these cases. If you really wanted to be an athletic contest, make them carry their own bags and run between the holes, right? Huh?
There's plenty of golfers out there that are far from in good shape that are on the PGA Tour.
But they don't have some ability to set their own rules of competition. I mean,
They do.
They do. They do.
Under this court.
No, they do.
So
The PGA has the option. The PGA has the option of allowing, of giving him the opportunity to use the cart by the rules, but they just decide to use their discretion to say no, to say that he has an advantage, when in actuality.
Well, but in fairness, though, they say no one can use a cart. The way we want to set this competition up for professional golfers, for the elite in the sport, is no one uses a cart. And it may be, I think it's probably as much for television as anything else. But they don't, because, is it because they're a place of public accommodation that they don't get that right?
I think a good question would be to ask, can professional elite golfers only be not handicapped?
No.
Well, obviously.
That would be every professional sport.
Right?
I mean, they wear slacks during the game.
So,
I think they hurt themselves by allowing cards in the preliminary rounds, because they do allow cards beforehand, and then I think it has something to do with TV airtime, because you see every golfer, especially the big name golfers, shoot every single one of their shots, and that's because there's so much time elapsed between walking from one ball to the other instead of everyone driving on the cart. Touching back too about the fatigue, apparently it's an uncontested finding and it's not disputed that this guy endures greater fatigue with the cart than all the other competitors. So that was undisputed at the district level. And I see why the PGA wants to do that, because allowing one person to have that cart is almost a slippery slope, because you're going to have these people that are out of shape, that have no physical disabling, there's a disease the guy had that's not as severe as him, but they're just going to want to take the cart just because they are tired. But they address this and say only 2 other golfers have ever actually requested the cart. So even though theoretically it may sound like people are going to take advantage and exploit it, they don't.
Well, why wouldn't they? I mean, they take steroids so they can hit the ball faster and throw it faster. Especially where some of the evidence, my recollection indicates that they may play 36 holes in a day. Maybe more in some of the earlier rounds with rain and the rest. Jeez. If I get a cart, that gives me a significant advantage if I don't have to walk.
But he'll still be twice as fatigued as he will be playing 18 holes.
True. I'm worried about. Charlie talks about the slippery slope now. So now others get to use the cart too, or let everyone use the cart.
Under the act, and maybe it's just pure numbers on how many people are golfing at that level that are also disabled. It may just be the only reason why 2 people did it is just pure, simple, that there's not that many people out there that actually.
Isn't the ADA only individualized anyway?
It is.
So it can't open the floodgates in a sense.
Whoever can qualify under the Act should get a reasonable accommodation, and we'll decide what the reasonable accommodation is on a case-by-case
And I
basis.
think Charles right. They shouldn't have let him use the cart in earlier stages of competition. If they want to ban it, they should just ban it.
Because that shows it's not a fundamental part of the game.
Yeah.
You're not asking that a fundamental part of the competition be altered because they use it in other stages of the competition. Would someone who's a wheelchair basketball player get to play with a wheelchair?
I asked that question too.
You asked that question.
Like that, especially since they're getting mad at him. That's like getting mad at a person in a wheelchair, like, oh, his legs don't get tired. Like, why? I mean, he's in a wheelchair. Like, why would you?
So would you?
That fundamentally changes the game, I think.
Why would that fundamentally change the game and this
I
doesn't?
don't even think it's relevant.
You know what I mean?
Huh?
I don't even think it's relevant.
What do you mean?
Because he's good enough to play golf on the PGA Tour. If you find someone in a wheelchair that's good enough to play in the NBA, I really think that's impossible.
But what about that?
I think in part I could be a lot faster down the court.
Yeah.
All right, so I just keep the guy back.
Okay, you know what? Okay, you know what? I'll agree with you. Bad analogy. What about the guy with the springs on his feet? Remember the Olympics last couple of years?
Oh, yeah.
Oh yeah, it was big to do. He had lost both his legs, and he had sort of L-shaped legs instead of. Huh?
He killed his girlfriend.
Yeah, right. That is the guy, right?
Yeah.
And he killed his girlfriend. Would he get to play? So he doesn't have a wheelchair, but he's got these feet, the legs. That what they're saying is he could run faster in part because they're graphite, so they're very, very light.
Well, he couldn't in the end.
He didn't win.
Okay, but with next generation, okay, and. Would he get to play in the NBA?
Again, even though traveling is ridiculous in the NBA, I have a hard time stopping.
He's kidding. But wait a minute though, because my guess is.
I mean, you got to have the physical ability to play. Casey Martin has proved he can play in the.
But my guess is with those legs, I could dunk a basketball.
You might be able to dunk, doesn't mean you have the skills to play the game other than jumping in the air to dunk a ball.
Well, okay, listen, he's pretty fast, and now he can dunk a basketball. Those seem to be two pretty good, and obviously I should be able to defend if I can spring up 6 feet in the air.
I don't think they benefit that much. I mean, I don't see people cutting their legs off to play in the NBA.
There was a huge, first of all, there's a lot of people without their legs as a result of their service to the country, so I'm not sure anyone needs to cut them off to do it. But this was a huge to-do as to whether he would even get to race in the Olympics. And because there was a real concern that there was a competitive advantage to his disability, and especially with respect to the manner in which the prosthetics were developed and designed. I mean, they were designed to make him faster and to jump higher. So let's assume that someone does petition. Would you let them? But for the disability, I need an accommodation. I'm not even sure I need an accommodation. I don't want a cart. I just want to play. He gets to play? Right? I'm not even sure I'm asking for an accommodation if I think about it. They can't have a rule that says you must use your own legs. Right? Go ahead.
This is an event that's essentially open to the public, whereas the NBA isn't. The NBA is a private organization.
All right, it's open to the public.
Well, the public can watch it. The public attends on paying.
Anyone who's good enough in the public to make it through the preliminary rounds, as I understand it, is on the PGA Tour. So
Yeah, but anyone can try out.
Anyone can try out for either, right? I mean, I would assume that there's a tryout process. Certainly, that's how he got into the PGA part of it.
In the NBA, though, you have private organizations within there that hire.
PGA is a private organization.
Well, they don't hire anyone. They don't have employees like a basketball organization does. Every basketball player is an employee.
Fair enough.
Yeah, this
Golfers aren't employees of the PGA Tour.
So you're telling me that if an NBA team wanted to ban blacks or Asians or women from playing, they
I'm
could?
saying they could hire the guy with the Blade Runner if they wanted.
What?
They could hire the Blade Runner if they wanted.
They couldn't do it on Title I. Title I, they would just the contractors,
They're
right?
employees of the team.
No, but I'm wondering, as an employer, any of us as employers and as employees, even for private companies, right? They can't say, no, I'm sorry, I don't have to make an accommodation for you, Mr. Coyne, because I don't like white guys. Right? I mean, the ADA, Americans with Disability Act, applies to all employers over a certain size, and the size is small. I think it's 5 to 15. I forget what it would be, but the number is small. And NBA teams obviously employ more than that. So forget your easy out. Would he get to play in the NBA? Would he get, if that's a needed accommodation? Because how's it? Yeah.
According to the court, yes.
According to the court. Because I'm not even sure what the reasonable accommodation I'm asking you for is. All I'm asking is to not be discriminated against on the basis of my handicap.
I think the argument is if it doesn't bankrupt you, then you have to do it.
If there's what?
If it doesn't make you go broke, you have to do it.
And it's not going to make you broke. I'm not even asking you to pay for any of this. So does any of you worry that this sort of potentially changes the nature of the competition? No?
It could. I mean, I don't know about in that case, but it certainly could, depending on the accommodation of the disability, I suppose. Now that they come out with these medical, whatever they come out with. I mean, they have, you're wearing like an exoskeleton suit, or who knows what they come out with soon, I suppose. But I guess it would be on a case-by-case basis.
None of the other golfers, none of the other basketball players, those that might want to make it, are placed at a disadvantage because of what some would see as a competitive advantage granted to a few?
I think that's the part that bugged me. I think the rule didn't change how the PGA conducted their competition. I think the mere fact that they said, on this last hole, this is how we want you guys to do it.
But it's not just the last hole. It's the entire, I think the last hole argument is, for the majesty of it, that's where it would all kick in and all the rest of it. But they're expecting him to walk the entire course. And that's where his argument on the fatigue is even more powerful, is that, because what's the number? Those of you that golf, what is it? 3 miles or 7 miles over the course, depending on how much you're going to lie about it? Huh? It's 5 in here?
This is a lot more for us. Twist brain balls every day.
Lucky you got the cart with the beer cooler in it, right? So tell me, is it concern to you that there is an unleveling of the playing field for some? Because I know you're not PGA golfers and you're not professional basketball players, but I did see a little reference here to the bar exam, and in a minute we're going to look at medical school and the like, so maybe it hits a little closer to home.
I think it was the right call at the end of the day, and they gave him his opportunity, and it turns out he wasn't good enough anyway. He didn't get to the qualifying school. So
the PGA, like us all, has to comply with federal law.
Yeah.
It didn't fundamentally change what they did, but they were required to make a reasonable accommodation for someone who had a disability. Couldn't discriminate against him on the basis of his handicap. It says, there's a footnote 1 in here about the California bar exam is covered by the ADA. So I guess now we can switch to that question a little bit. Is the McGinnis versus the University of New Mexico School of Medicine, and the bar exam as well. Well, tell me about McGinnis first. First it says that the court granted summary judgment. Our jurisdiction arises, blah, blah, blah. We affirm the district court's grant of summary judgment. What summary judgment?
No material facts to dispute.
Tribal level. Okay, no material facts in dispute. No facts of consequence in dispute that rise to a tribal level. The moving party is entitled to judgment as a matter of law. So it's going to be a pretrial device that eliminates the need for a jury trial, and really based on the idea that there aren't material facts. There aren't facts of consequence that are in dispute in order to resolve it. It simply becomes a question of law. If it becomes a question of law, then the court, the judge, is able to resolve questions of law because juries are going to determine those questions of fact. But in this case, there are no questions of fact that need to be resolved. Mr. McGinnis entered the University of New Mexico Medical School in 1992. He has a bachelor's in chemistry and biology, a degree in physiological psychology, and a doctorate in psychology. He worked as a forensic chemist, and he continued to work as a clinical psychologist during med school. Mr. McGinnis experienced anxiety in chemistry and mathematics courses, me too, in both graduate and undergraduate school, but developed study habits that allowed him to overcome his difficulties. What is his complaint?
He has anxiety.
Huh?
He has anxiety.
He has a...
I mean, it just seems like, why don't you just say you're not good at those courses, and that's why you have anxiety? It's not a disability.
It mitigates his it mitigates fine. Yeah. he has college.
Well, he had mitigated them previously, okay.
Right.
But now he's having trouble in biochemistry. He's got anxiety as a result of it.
We had a bunch of mistakes.
And then he tells him he needs no accommodations. He took the biochemistry course, received a grade of marginal. If you get marginal grades in more than 15% of your first year classes, you must repeat the first year or leave the program. McGinnis chose not to repeat the first year curriculum. Instead, he filed suit because he wanted a reasonable accommodation for his disability.
In the first place, he never even asked for an accommodation.
Exactly what I was going to say. In the beginning, he says, look, I have this, I don't need any accommodation, just don't be...
I'm lazy.
Yeah, just don't perceive me as lazy.
Clear with the grades is something I think, yes.
Yeah, give me a clear guideline of
Set
grades.
clear grading standards is what he said.
Okay, and then he gets the marginals, and they even say, okay, well, you can retake the course, and he doesn't like that. You go, no, I'm not retaking these, I'm taking your course. I just don't get it. It doesn't really look like he really did much.
Well, so what, are you guys saying you don't think he has a disability? Or you don't think they're required, and if he's got no disability, they're not required to make a reasonable accommodation? Or are you saying he's not an otherwise qualified disabled person is entitled to a reasonable accommodation?
He's not
I think
disabled.
both. I mean, they gave him a reasonable accommodation, take it again, and I don't think he has a disability.
It says the term disability means a physical or mental impairment that substantially limits one or more of the major life activities of the individual. Major life.
What's the major life?
Learning would be the argument.
And it's hard to make that argument because look what he's already accomplished educational-wise with his disability. And now you're going to say that it is a disability even though you got a
I think
doctor.
I'd have a disability too if I was in that class.
Learning biochemistry. Disability.
He's handled it.
You're going to lower your standards for medical school, and we'll have more malpractices.
Well, so is that what it is, that the profession gets to set certain minimum standards, and if you can't achieve that, either you're not otherwise qualified, or even if you are otherwise qualified, it's not reasonable to say you don't have to take basic anatomy, you don't have to take biochemistry. You know what? I hear people struggle a little bit with con law. Now you don't have to take con law anymore because you get anxious sitting in class with those folks. Which I don't blame you.
Since they give deference to the schools, they can't just give away degrees and have them earn. They have to earn it by their merits. So.
Well, are there some basic requirements of PGA Tour, of med school, of law school, that if you can't meet, I need a doctor that knows anatomy. I need a lawyer that knows, well, I was going to say criminal law. I guess we all do.
Well, when I think of maybe like a case that he could bring, say he's hard of hearing and they don't give him an alternative to hear the lectures, that would be like something you would bring suit for. Not because I could pass all these prior classes, but now I'm in a class that's so difficult I can't pass. It's my anxiety. That's my disability. I don't fall for that.
Well, so, but I'm hearing that you think he's sort of a malingerer, a faker.
Yeah, because if he really had something, he would ask for accommodations before, at the very outset, instead of when he failed the exam.
Well, suppose he did. Suppose he, because I agree with you. First of all, it is incumbent upon the individual to seek out the accommodations. As a general matter, you're not required to make accommodations when none have been requested. Okay, there's a bunch of cases with respect to that. But suppose he had asked at the outset. Are you guys telling me your decision would be different? Because that's not the feel I'm getting from what I'm hearing.
What did he ask for?
Well, he says the parties agree. Well, okay. He says, I get severe anxiety when I take chemistry and mathematics tests. I'd prefer not to have to take them.
Yeah, that's not
reasonable.
Huh?
Bye-bye.
That's not. Why is that not a reasonable accommodation? Assuming that that's true.
Every one of us here has severe anxiety.
Test anxiety.
Yes, at exam time.
So tough luck.
Yeah, we're here, we're doing it.
Test measures emotion.
Go ahead.
Too bad.
Well, I respect everyone's opinion with that, but I'll open up. I was actually under Title I IEP. It's called Individual Education Program. It's similar to what this guy had, except it's real.
Oh, we're not judging him, though, are we?
But what they would do for me when I was younger, when test time came, they'd put me in a different room. there'd be no time. You know, everyone else had a timed exam. I had no time limit. I had someone in there with me, so if I had, random questions or questions that they could answer it for me. It was just a different setting. I wasn't in, a rigid setting. It was more comfortable. So I understand what they're saying. But
Would you give them time?
Yeah.
But that's different.
Would you give them a separate room? But at some point, you're going to draw the line on how far down that road you go because you're going to tell me it's not reasonable, right? You wouldn't excuse them from the course?
No.
Would you excuse? Let's take it close at home. Would you say, no, you don't have to take con law?
No.
It's a required course.
That's not reasonable.
It's not reason. It's a required course.
Well, property.
No.
They're all required.
Huh? Well, but so then I can just set what the required courses are and you're going to take them, or do we have to look further as to why they'd be required? With recognizing that they're going to give deference to the profession and the institution, which they are. The language is in here.
Well, they're part of your basic competency for what you want to do. He wants to be a doctor, so.
Well, but evidence. Evidence is not a required course at some law schools. Here it is. So law schools set different standards for what's required. Here, I'm kind of surprised that mathematics is required in med school. I could see chemistry.
That's for billing purposes.
That's right. All you guys got to know is what's divisible by 3. So I would hope that they'd know mathematics too, by the way. But so if it's a core requirement needed for the profession, maybe we'll give you time. Maybe we'll give you a private room, but you're going to do it.
Still have to pass the exam.
What about? I do have anxiety. I just can't take it this month. I need to take my exams after the Christmas break.
Take a Xanax and get some therapy.
No. Is that a reasonable accommodation, or that's not? Complying with time limits, certainly for your profession, are they fundamental to the ability to be otherwise qualified?
I don't know.
Huh?
That's not that outrageous, I guess. It's not that outrageous.
Well, have you ever heard statute of limitations or
Yeah.
and the like?
It just appears as though it's an arbitrary preference from the individual as opposed to an actual disability that affects them. This is very topic specific with this guy. And with regards to this, in comparison to PGA, I think it's a matter of public policy that they want to give deference to our institutions, educational institutions, as opposed to maybe some golf PGA, which is a for-profit and public entertainment purposes. You don't want your doctors being given this sort of latitude. If somebody wants to, I don't know, well, whoever wants to watch golf on TV, up to them. But playing is one thing. Whatever. But I think it's just a matter of public. At this point, they're going to say, no, I'm sorry. The fact that you don't like math or whatever the case may be. It's too topic specific. It's not really a learning disability per se. It's certainly not an ADA disability by any means.
Do you want some minimum level of qualifications for the people that ultimately, doctors and lawyers say, who are going to provide what you would see as essential services to you?
You can be a surgeon if you have a handshake. It's unfortunate, but you can't.
Yeah, now they
Yeah,
That's a different.
No, you can do it on you. Not me. You don't know.
Many of your clients would have hired you if you told them you didn't know anything about evidence.
I don't disagree.
But I think that's a different. I think that's a different disability as far as the hypo that you gave, as far as accommodations because of a disability with anxiety or stress in law school. That's part of the process. I would say
Anxiety and stress are part of being a lawyer.
Right. Like if you have a client that's like, wait, I don't know, if we get to trial, I don't know how I'm gonna, it's too stressful for it. Then you're gonna be like, okay, you know what I'm saying? It's part of the job, just like a doctor. If your surgeon can't handle stress or being in a stressful situation, then you probably don't want him to be your surgeon.
Well, what about that? Because he's got an anxiety disorder. Are there some then disabilities that by their nature are disqualifying from the language of being otherwise qualified? Is that,
Anxiety can be managed quite well. It can be.
But the anxiety is it's an emotion. It's normal. So I would say, especially in certain professions, like it comes with the territory. So.
Go ahead, what?
There's I actually know people with severe anxiety disorders that they're crippling. They can't drive, they can't like do stuff. So, I think then you start to say, are they qualified for the profession? But I think like we're all looking at it as anxiety is like, oh, I get nervous before tests. But like, I don't know about this guy, but there are like, people do have crazy anxiety. I
had a client describe it one time at deposition as the feeling of being hit by a bus right in the chest. He said he said it was that disabling. He said you could not understand it if you didn't experience it, but it was like a bus hitting you square in the chest, and a big strong guy too. But that's how disabling it was after what had been done to him. That's really couldn't breathe, gasped for air, thought he was going to die. I absolutely thought he was going to die.
I was going to touch upon that too. I don't know what severe anxiety is because I don't have it, but from people that do have severe anxiety, like you said, it can affect a major life activity. But looking at the bigger picture in this case, getting your doctor's degree is not a major life activity. They talk about walking, day-to-day activities. Getting your doctor's degree doesn't qualify into that major life activity part in order for the ADA to apply.
Well, there is language, not just in here, but I think in other cases that we could look at, other educational cases, that say not everyone gets to be a doctor or a lawyer. The fact is, you can learn, but to get to that level in any profession, in any school, means that there are others that aren't going to be able to achieve that. And so you've learned, and look, in the history here is that this person does have the ability to learn, frankly can learn a lot in medical school, but in a few of these courses is struggling, as I think we all would struggle in some of these courses. That doesn't mean you are disabled from learning. It means maybe medical school, law school for others, is just not in the future.
He also aggravated the court by slowing down discovery for improper reasons and everything, so that didn't help him. Shouldn't help him at all.
Also, I don't remember his anxiety being medically diagnosed. Doesn't that matter for the ADA to kick in?
I don't think, not necessarily, because under the new standards that were added to it in 2008, even if you're regarded as having a disability, you're entitled to an accommodation. So the fact is, oftentimes it's going to be diagnosed, oftentimes there'll be medical support, but the more recent trend of cases is even if you're regarded as having been, you are considered to be covered under the Act. And I'm looking at the top of 79 where it says the parties agree that Mr. McGinnis has an anxiety disorder that manifests itself when he takes chemistry and mathematics tests.
So just those subjects.
Well, just those subjects, and the district court, it says correctly, you're right, district court correctly said that's not really a disability under the ADA because you can learn. When we say learning, we're saying learning, generally, not just learning nuclear medicine or things along those lines. It says, Mr. McGinnis must demonstrate that his anxiety impedes his performance in a wide variety of disciplines, not just chemistry and physics, and he's failed to do so. And the fact is, he also had the ability to mitigate some of his disabilities in the past, working harder, more notes, whatever it was, and he stopped doing that. And I think most of us felt that in looking at it, they went out of their way to allow him to repeat the first year curriculum, which he, like others, were allowed to do, and instead he chose not to do that.
I like when the court says, just like eyeglasses, they can fix mitigate your impairment, so it's not a major life impairment.
Well, there's a whole line of cases along those lines about hearing difficulties, seeing difficulties. To some extent, sit closer. Try and tape the information. There are ways you can try and self-help and accommodate. And I think they're pointing it out there, which is not as found as much in the new cases, but in the earlier cases they talked about that if you can mitigate, you need to, and it's not incumbent upon the employer or the school or others to have to do that. The more modern trend is that with or without mitigation, you may still qualify under the Act, but the level of reasonable accommodation under those circumstances will be examined. And then lastly, I think it was Mark who pointed out the sanctions and the like for what Mr. McGinnis was using here as he litigated the case did not sit well with the court at all. And so that was, I think, some concern about. I don't know whether it's fair to say that it deliberately it cost him the case, definitely, but it certainly colored, I think, the court's thinking with respect to Mr. McGinnis's bona fides here as how this went down. So we'll talk next time about Toyota Motor Manufacturing versus Williams.